Right now, our next guest is the former chairman of the world's first independent body to review miscarriages of justice, Britain's Criminal Cases Review Commission, Professor Graham Zellick. Some 70% of the cases it referred back to the courts following investigation was subsequently overturned. Among the cases the Commission helped to overturn was that of Paul Blackburn, who spent 25 years in 18 prisons in the United Kingdom from the age of 15 until his conviction for attempted murder was quashed. By then, he was in his early 40s, and his story remains a very sad one. So why are more countries setting up independent institutions to review miscarriages of justice? And what does this say about the state of our court systems? Professor Graham Zellick's in New Zealand currently and joins us in the Wellington studio. It's lovely to have you with us.
Thank you. Good morning.
So why was the Commission set up in the first place?
It was set up following the recommendation of a Royal Commission on Criminal Justice, which had itself been set up after a series of shattering miscarriages of justice in a whole range of serious cases in the 1990s, mostly concerning serious terrorist offences. And public confidence in the English criminal justice system was shaken to its foundations. We'd always believed that we had a really very good criminal justice system, one of the best in the world, and were very complacent about its effectiveness and its qualities. And that proved not to be the case. And so the Royal Commission recommended a number of procedural changes on the one hand to minimise future miscarriages of justice, but also recommended the creation of permanent, independent machinery that would pick up any miscarriages in the future that nevertheless arose. And to its eternal credit, the government acted on those recommendations immediately.
Why are they needed? There is the lower court, there is the High Court, there is the Court of Appeal, there is the Supreme Court and or the Privy Council. Why can't the justice system itself find flaws?
I would say, first of all, that once you set up machinery of this kind, it becomes part of the justice system. So it's not necessarily as if you're grafting something on. You're merely adapting the justice system to accord with realities. But there are two very simple answers to that question. The first is that the judicial system is a human instrument and is inevitably imperfect. And from time to time, it will make mistakes, it will overlook things, and it would be crass to think that that would never happen, and it wouldn't be sensible to have some long-stop machinery to prevent it. In fact, there always has been some mechanism for picking up cases that have gone wrong. It's just that those mechanisms in most countries have been seriously defective. The second thing is that you sometimes find things later that simply were not available. Witness, evidence, new scientific techniques. Things happen which simply were not available during the first set of proceedings. So once again, the door needs to be opened to correct those mistakes.
So how does this differ from the role of an appeal court or a Supreme Court? Let's look at the different things you might look at. Are you second-guessing the decision of juries, or is it the quality and presentation of evidence that is your focus?
It's neither. And you've got to understand that certainly the Criminal Cases Review Commission commissions in England and Scotland, which are the two I know most about, there is only one other in Norway, which I know less about, harmonise with the court system extremely well, and they're designed to do so, and not to supplant them or oust them in any way. So the first thing to remember is that the Commission refers cases back to the Court of Appeal on the grounds that have been specified. That's the first thing. The second thing is, why then do you need to have a body? Why can't people go straight to the court? And this is the crucial difference and the singular importance of a review commission. And that is that it isn't just a reactive body in the way that a court is, that sits back and considers evidence and argument. It's a proactive body that goes out and instigates investigations.
So what sorts of things could have gone wrong during the trial or could have been uncovered later? What sorts of things would the Commission have picked up?
You, for example, might find evidence relating to the history of a principal prosecution witness that hadn't been uncovered before. It may be that you discover that the evidence, often critical in a criminal case, given by an expert witness for the Crown, was seriously defective. That's been one of the common findings. So we have gone to different independent experts, sometimes several, and had the tests carried out all over again with sometimes very different results. It may be that you come across a piece of physical evidence that hadn't been properly examined at the time. A new witness may be found who wasn't available at the time of the trial, or either had gone missing or wasn't even known about.
All of these things point to one of the issues surrounding our very court systems, those of us that are not inquisitorial systems, which is that you have two sides eliminating evidence they don't like and selecting that which they do like, and in some ways are you compensating for the potential weaknesses of that?
Only up to a point, but not really. There's a lot to be said for the adversarial system, and on the whole it works well and produces the right results. And remember that criminal cases review commissions pick up a tiny proportion of the number of convictions. So far from suggesting that the criminal justice system isn't working well, it does the very contrary. It isn't an alternative to getting the basic rules right. One of the significant changes that was made in England, and I don't know the position in New Zealand criminal procedure following the miscarriages of justice, was the introduction of a new regime for disclosure of evidence, which requires the Crown to hand over to the defence all the evidence that they're not using that may have any bearing on the case at all, either that suggests the Crown case may be weak or may assist the defence.
What is extraordinary, though, is that it might be a very small proportion of total cases, but of the 30 to 40 cases that you were seeing a year, 70% were subsequently overturned by the courts. That is a very high figure.
Some say it's too high. The test that the English Commission has to apply is having reviewed the case and having found something new that wasn't considered by either the trial court or the Court of Appeal, is whether that raises a real possibility, they're the words in the statute, that the conviction will be quashed. So it isn't our job to second guess, and I come back to something you asked earlier, the Court of Appeal. The Commission doesn't do that. It's simply a judgment as to whether there's a real possibility that the court, on considering it, will quash the conviction. So
the second guessing was of the jury, which is a different matter,
yes,
really, isn't it? Yeah.
Yes, and we don't, and the Commission doesn't do that.
What you don't do either is decide on guilt or innocence, which makes you different from many of the independent bodies that are being set up, the so-called innocence projects, which do set out, do they not, simply to find out whether a conviction is unsafe or to find guilt or innocence.
Yes, they have a very different remit. Of course, they're not official bodies, and one reason why they do that. Well, there are two reasons I think why they do it in America. One is that the courts are already very receptive to legal arguments. You can go back to court umpteen times in the American system in a way that you certainly cannot in the English. The other thing is that they're simply very pressed for resources and therefore have to find a way of deciding which cases to accept. But in my view, it would be profoundly wrong for a review commission set up by Parliament to take cases or review cases only on the basis of innocence, because that isn't the fundamental basis of a criminal trial in the common law system.
So it's simply the safety or otherwise of the
conviction.
That's
all. That's what matters to start with, and that's what should matter throughout the process.
Some of the cases that you've investigated that you might highlight, I know the Jill Dando murder had very high publicity here. This was the television presenter who was murdered, I think, on her front doorstep. What were the elements of that case that came to your attention?
That was a fairly simple one. Our investigation was very wide-ranging, but in the end, it came down to one piece of evidence which had weighed very heavily with the jury, because The rest of the evidence against the defendant, Barry George, was really rather circumstantial and slender. But the one piece of evidence that I suspect weighed very heavily indeed with the jury was a microscopic speck of gunpowder residue that had been found in the defendant's overcoat pocket. And so it's smaller than the human eye could see. And it was said that was a sufficient link with the murder. Subsequent examination of that and a review of the forensic evidence suggested that the weight that was placed on that was quite improper and inappropriate. So once that was removed from the equation, there wasn't much evidence left against him.
Another case, the mother of two so-called cot death babies, or sudden infant death syndrome, we called it here. What was the case that came to you there?
Well, we had a number, because that, rather like the 1990 cases that I referred to at the beginning, there was a strong feeling that the justice system may have dealt very badly with very large numbers of mothers who had been sent to prison for the murder or manslaughter of their infants. And the government, the Attorney General of the day in particular, took it very seriously and reviewed every case over a 10-year period. As it happens, we ended up ourselves reviewing only a handful of cases and referring even fewer, certainly in single figures. But in the case that you refer to of Sally Clark, there were two things. First of all, the evidence of the chief Crown expert was a leading paediatrician who had featured in many of these cases, and whose so-called expert evidence on a number of fronts was highly suspect, grossly prejudicial, and found to be seriously defective. In addition, some medical evidence was found about one of the babies, which would have explained the death on other grounds anyway.
You have alluded to, and I think it's quite a strong issue for you, the quality sometimes of expert evidence that is put to the courts.
Yes.
How would you sum it up?
Once again, it's only a small proportion of cases, but it's often quite a small number of experts who feature in the criminal courts because, for instance, there are a small number of Home Office pathologists who carry out post-mortems. And if you've got one of these senior doctors who's not very good at his job, quite a number of convictions may have been returned on the strength of that defective evidence. Again, in the case of the sudden infant death syndrome cases, very many convictions were based on the evidence of Sir Roy Meadow, all of which were clearly questionable.
So you've called in the past for an overhaul of expert testimony. What would you recommend?
That was a personal view. That was the Commission doesn't do that and has no remit to do that. I certainly felt that there were issues, not only in relation to the quality of individual experts, but also into what constituted expert evidence. I think the American courts have fashioned much stricter and more rigorous rules governing the admissibility of such evidence. We are much more lax, and we've had some funny cases about lip reading and ear print evidence and so on, which isn't really very compelling.
Ear prints?
Ear prints.
Are they like fingerprints, or?
Well, I think they're not. That's the problem.
It is very difficult reading, the reading of Paul Blackburn, jailed at 15 for the attempted murder of a 9-year-old boy, served 25 years in 18 prisons. Could have been out after 10 years if he admitted he was guilty, but as an innocent man, obviously doesn't want to. I appreciate that you don't have a finding of innocence. Never did, and was released after 25 years. And reading of his state of mind in his 40s, now that he is free, pretty hard stuff to read. Are there others, given the 70% rate of overturn for those that you've sent back to the courts? Are there others who are in prison who, if not declared innocent, ought not be there?
Inevitably, any review commission can send a case forward for a further appeal, only if something new has been found. And it may be that nothing new is found, but that doesn't mean that it isn't there. Once again, even a review commission is only is an imperfect instrument.
Which comes back to who gets justice and who doesn't, because those who may have anything up to 7 figures to keep fighting their case, or the case of someone that they are backing, might have the chance to uncover that unknown evidence, and someone without those resources doesn't, rots in effect. Who brings cases to your attention, and on what grounds do you investigate?
That is, you see, exactly the problem that a statutory review commission overcomes. The vast majority of people who come to us are not backed either by money or even legal representation. It takes nothing, no formality and no cost to apply to the commission. Just a simple application form, and that sets the wheels in motion.
And how do you decide what you're going to take on and what you're not if no one's come even with initial evidence to give you?
The Commission reviews everything, 1,000 cases a year. The Commission reviews everything. The degree, the intensity of the review depends on what you find as you go through each stage. You start by getting the Crown Court material and the Court of Appeal transcript, and you build up, and through expertise and so on, you are able to judge whether to take it further or whether nothing is revealed that hasn't already been fully considered.
And obviously in a country like this we have a lot of cases, and it sometimes just about seems every high-profile case ends up with someone somewhere saying this person shouldn't be in prison. We have a fledgling innocence project underway based at one of the universities, and I'm not sure about your opinions on the usefulness or otherwise of the innocence project type setup. Do you believe that in a jurisdiction like ours we could do with a similar process here, not only to perhaps to find those cases that ought to go back, but to reassure us that there may not be that many of them?
Well, precisely. That last point is terribly important. And the other thing is that when a review commission examines a case and says, we have found no fault here, we're not going to refer this back, that is a very firm affirmation that the justice system has worked as well as it could in the circumstances. In Britain, we had some long-running campaigns. For instance, I don't know whether the name Hanratty means anything to you, a man who was hanged for the murder of a man on I think it was the A3 highway, a horrible case, and but for decades there was a campaign that he was wrongly convicted. It was someone else who did it, and books were written, and the whole thing wouldn't go away. And eventually it came to us because the English Commission's jurisdiction extends to people who are dead as well as those who are living, and the Commission looked at the case. It wasn't done in my time, it was before my time, and his body was removed from the grave. DNA testing was done, the exhibits had been retained, and it showed beyond the slightest doubt that he was the murderer. That campaign is now at an end, and the public is reassured.
Thank you. Professor Graham Zellick has been brought to New Zealand by the New Zealand Law Foundation. His first public lecture of a series is tonight at Wellington's Wellesley Club at 5:30. But don't pack it out, will you? Lovely talking to you, Graham Zellick.